I've been very involved with these state laws. When I came out of the administration, going back to being a happily obscure Midwestern University professor, I ended up getting dragged into a bunch of things. And one of them was, I've loved, I'm Republican, pretty conservative. I have a lot of Christian friends who are activists, and they wanted to do something about pornography. And I was always very ambivalent about that. I'm a good civil libertarian. But in my last few years as teacher, I've really sort of changed my perspective. Mostly because my students, who are all young 20s, are very unhappy. And that's not just my personal data point. We know that the millennials, the 20-somethings, the lowest rates of dating, lowest rates of sexual relations, highest rates of, especially among young women, of mental illness, of loneliness, of all these bad things. I'm the nephew of not one but two Freudian analysts, so I think, oh, it must be sex. That's the problem. And I thought that I think porn is part of the problem because it is an alternative to the real thing, especially for men. On the other hand, I'm very ambivalent about it. I think it's a very anti-male sort of kind of law because guys are very visually oriented with their sexuality, and so it's like no, milkshake for you, so to speak. Never mind. Can we rewind that, please? I found myself being pulled into these things as friends with some of them, and also because we'll talk a little bit about this ruling that just came down. The best minds have not been on thinking of new ways to protect children from media. The best minds have been on the other side. They've been either liberals or they've been libertarian Republicans. And I always thought there were a few ways through that we could do this. But I still am ambivalent because of the one, I thought it was anti-male. Number two, I don't like the idea of age verification. I think it's a very scary idea. So about 2 or 3 years ago, I was at a FUTO meeting, a group of FUTO people, and we were talking about anonymous authentication of individuals. Whether you could take the idea of public-private keys and apply it in a mass-scaled way so that you could actually find anonymous authentication of individuals. Of similar, not quite, this technique we were talking about was cryptographic. I think something that Alan was talking about earlier at the very beginning of the talk was another kind of decentralized authentication. And so, would it be possible in these laws to create and encourage a sort of decentralized authentication, because I think that actually could be pro-privacy. If you could find third parties to authenticate, trusted third parties to authenticate, they could authenticate not just with platforms, but with the government. And so you could be anonymous. They are then with banks. So you could actually have, hold money in bank accounts in the United States anonymously in a way that would be more invisible to regulators. So I thought, okay, fine, I'll go this route, see what happens. I got involved with some people. The way you laugh, exactly. The anti-porn people, it's very dark. Actually, Jean Twenge, who was a psychologist at San Diego State, is the leader in this area, and we wrote this report, and Utah adopted pretty much the entire law, and then it's been copied, various iterations, one of which was Texas, and they're all changed, but the basic idea behind this is that the platforms have to authenticate age. And everyone thought we were nuts. I was, people wrote to me, this is irresponsible, this is going to fail, because of there's very strong precedent against it. Before we get to the case, I do want to talk a little bit about the law, and here it is. Everyone gets to laugh at my nearsightedness. So, this is sort of a tech conference, and the question is, how do we, verify age, and who's going to have that verification. And I worked very hard to keep it as open-minded and Catholic as possible. So, there's digital identification, complied with a commercial age verification system, government-issued ID, or commercially reasonable method that relies on public or private transactional data. So, the idea would be it's an opening for third-party verification. So the idea, you could use something maybe with zero-knowledge proofs, where you could use you could take your ID to a third party, trusted third party, say, I am above 18. They would verify you, send the token over, and you could start an account. That would be the idea. That's the idea I'm hoping for. Whether it happens, we'll see. But I think that is a tech solution. So, getting back to the story, everyone thought these things would fail. They were rejected in. And very nervous about it. So Arkansas and I can't remember one other case, district court turned it down. They declared it unconstitutional, and then Texas's law, which is by the district court, declared it unconstitutional. Surprise, surprise. The Fifth Circuit said it was constitutional. And I mean, this is the boring law stuff. You may or may not be interested in it, but there was this older case called ACLU v. Ashcroft that was, I think, 2003. It was a bell ringer of a case, and this was the first effort to require porn sites to verify age, and the court struck it down. It said it's unconstitutional. And the reasoning was interesting. Primarily, they said that verification, self-identification, is a burden on speech, of adult speech. And never was quite clear how. I mean, how is verifying your age a burden on speech? The earlier case that they relied upon was a case called Ginsburg, where it had to do with girly magazines, and you had to have your ID, which you had to do with like the 7-Eleven. Then remember, there's times you get the Playboy, you had to show that you were above 18, and that was not considered restrictive of speech. But ACLU v. Ashcroft said, yeah, age verifying is burdensome on adult speech, and didn't really get into the details as to why. And we can all think why. Why do you think?
They don't want to be tracked.
Don't want to be tracked, especially when you're looking at compromising material. Exactly, that's right. And also the bigger issue, which is you also don't want to be revealing everything to these stupid platforms, because we love them here. They're great. So my vision, my hope was that a third-party verification, authentication system that could possibly be truly anonymous in some sort of cryptographic way could be developed. We could create this market. Whether that happens or not, if it did, however, it would very much undercut a lot of the justifications in this old Ashcroft decision, because they really were concerned, if you just read between the lines or just read the lines, they wanted to protect people's ability to, roam around the internet uninhibited. And, I see that, and I don't see that. I mean, I think that's an interesting sort of human-tech combination question. I was very enthusiastic 20 years ago when this all started, but people don't go to the internet to read Lady Chatterley's Lover. They don't, go to the internet to, look at the erotic drawings of Picasso. They go to the internet to do other things a lot. And I think that does perhaps have a corrosive effect upon our relationships between each other. I'm a conservative. That worries me. So the idea would be, if we could, in fact, allow age verification in a way that wouldn't be burdensome to adult speech, in an anonymous way, perhaps that would make the Supreme Court happy. That was what I envisioned. That's not what the Fifth Circuit did, of course. The Fifth Circuit was a very sort of tricky opinion, and it was the sort of thing, I don't want to be too ideological, but it's the kind of thing that left-wing judges would do and go unremarked. And I think the Fifth Circuit took a right-wing trick. And what they said is, look, there's this older case that the one I mentioned, Ginsburg with the girly magazines, and the court didn't. The court said, oh, this is a rational basis test. Because we have to protect children from bad material, and as long as it's rationally related, meaning the court will defer to the judgment of the legislature. Ashcroft, which is that other case I mentioned, that was what's called strict scrutiny, meaning they had the judges really took off their glasses and made sure that the statute was really only going after the harm, and that the burden on free speech would not be so great. And since, as I said, the burden on speech of age verification was considered too great, the court essentially dumped the age verification law. What the Fifth Circuit did was say, oh, if you look carefully, and you sort of have to squint, the Ashcroft, they didn't really say what standard of review they were using. And if you if you look at the question presented to them by the parties, they assumed that it was strict scrutiny. So we don't really know what level of scrutiny to use. We will use this older, more deferential scrutiny. Needless to say, there are a lot of apoplectic constitutional law professors now who think it was a terrible decision. I don't know whether the Supreme Court will take it. We'll take this case. There's so many others bubbling around. But, it's a huge issue, and I'll just sum up with it by saying that it's both technical, legal, and moral. To the degree we think that there's any role in protecting children from content, we come out one way or the other on this. To the degree that you think that authentication can be done in an anonymous way, in a way that protects identity, in a way that doesn't further render us naked and obedient before these platforms, you come out one way or the other. And then the legal question, which is, what standard of review should courts look at when examining statutes which purport to protect children? How do they look at statutes that are trying to, give parents an ability to shelter and curate their children's environment? All normative questions, with no right answers or wrong answers. This is the way you come out on it. Okay, so how much time do I have? What's that? 10 minutes? 20 more? Okay, we can take questions. I'll go on.
Why is it so hard? I have a company and we have a flow where we do ID scans, and we have a mortgage flow. Why is it so hard for a Pornhub to add that in? It's in Stripe, it's a commodity. Would that not fit the test of verification?
Yeah, it would certainly. And if you want to start, developing that.
No, Stripe has had this out for 10 years.
Right.
It does an ID scan, it gets the barcode, it
Yep.
gives the information.
And
That's been a commodity for a decade now.
Right. And the interesting legal question, though, it's not so much the burden on Pornhub. It's the burden on the adult speaker who wants to look at porn without having his sense of freedom being inhibited, and that arguably would be somewhat inhibiting to the adult speaker. So, yeah, and that's the issue. I think it goes a little bit more broadly too. It was something that Alam's mentioned, where will we have to authenticate? Oh, I'm sorry. I was going on. I was like, oh, I can talk about myself. So I was like, go ahead. So.
I'm just wondering, practically speaking, because even if Pornhub is if they have to put those verification in place,
right.
and it's gonna. I think the problem they have is that they don't want to reduce traffic. People are going to be wary of that, and therefore they're just going to go to other porn sites and not Pornhub. But can't they just use a VPN and go to another country where they don't have this legislation?
Yeah, exactly. And so why bother, right?
Yeah.
And this is a discussion I've had with a gazillion state legislators on this stuff. And my attitude is, it's about shifting the median and about making it more difficult. If you look at the studies, and social science is what it is, psychology is what it is, but one of the problems is you want if you have a choice between working hard to go ask a girl on a date or working hard to make some computer program in order to get pornography, okay, you just want to raise. Well, interesting. Yeah, I don't know. We want to rebalance that a little bit. I mean, I think there are a lot of conservatives in the country who want to rebalance it in a certain way. Is that a good or is that a wicked or a meddlesome thing to want? I mean, no. I mean, I look at my students and it's like, yeah, they need something because they're not happy. Yeah.
So, with respect to, you said that there was another state that had a circuit court say that it was unconstitutional.
Yeah.
With respect to the state constitution or the federal?
Federal constitution.
So, isn't that inherently is it a circuit split? You said that the
right. It was at the district court level, so we're not at the circuit court level.
Okay.
I mean, a lot of people think that the Fifth Circuit opinion will be appealed and they'll take it. I don't know. Ryan's a better court watcher than I am. They may wait for another one to happen.
Are they appealing that one?
We will see. I mean, I bet they will.
70%.
70%? Yeah. Okay. There you go. The expert. Yeah.
I just have a question on, like, you mentioned platforms like Stripe, uses like Persona and whatnot, which, that's for KYC, though. That's often about, like, validating who you are.
Yeah, right.
Your age, who you are, they get all the data, right? In which case, that makes it vulnerable to the case that you mentioned before, where you're saying, okay, well, that inhibits freedom of speech,
right,
because if they know who I am, blah, blah, blah.
Right.
But are there some zero-knowledge proof, commercially available applications or frameworks?
Well, if anyone can help me with that, so I actually did a working paper about that in theory. It was, yeah. Well, there you go. I mean, I understand that they're using in crypto. That's my understanding.
Yeah, I was going to offer that. I'm working with an ex-DoD cybersecurity specialist who's developing an open source PGP self-sovereign identity system, and he's trying to stay off the radar because if he can do this, it kind of obsoletes most identity systems.
But then
Most
we
government.
don't want an identity system here. We want an age verification system.
Well,
right?
Sim, yeah.
Well, if you can do self-sovereign identity, meaning you can identify yourself and prove that you've identified yourself,
Yes.
like with a zero knowledge
Okay. So it is.
format,
Okay.
then that proof
Yes.
can be accepted without the identity being taken over.
And that's a tremendously powerful idea because you could do it not just to a platform, but you could do it to a bank. It's like the anti-know your customer rule.
Right.
And
you can create networks
Yeah.
of trusted.
exactly, that's right.
Okay.
And
Arbor does this exact thing. It is
that's right, exactly.
self-sovereign identity.
That's right.
So you could have a trusted verifier on Arbor to verify people's age.
Right.
As long as they're trusted by other institutions and websites.
That's right.
That should be valid, and those institutions and websites won't need to see any actual ID.
And that was my.
Play Store and APK.
Yeah, that's right, and that was my sort of psychological, justification for getting myself involved. It's like, oh, maybe it will develop, work for the development of these sort of authentication systems that could be used to ways to protect privacy. But maybe I'm just deluding myself. Yeah, it wouldn't be the first time. Yeah.
So you talk about this the standard for burden on the user.
Right.
Are there other cases that are well known related to this burden standard? Like what are some other cases where something is really acceptable or not?
Yeah. So I mean, I'm just. Virtually every First Amendment case asks that question: what is the burden on speech? So, to give a predecessor, Reno v. ACLU prohibited the sending of obscene speech or patently offensive speech to children, to known children. And the court said, look, this is going to get a bunch of people who can legitimately send, dirty pictures to each other lawfully, and they're going to be chilled because a child could see it. So it's too burdensome on adult speech because, people who have a right to send these dirty pictures will not do it for fear of being hauled into court. So that's an example of that sort of burden, extra burden. And Ashcroft took that idea and applied it to age verification instead of, sending, marginally obscene but just indecent pictures. So. Yeah.
I had a question that may be off topic, if so let me know. It's Section 230 versus common carrier.
Sure.
So my understanding is common carrier, which originated back from the original
Yeah.
national network, which is AT&T's, you send content, if you don't touch it or modify it, you can't be sued.
Right.
On the other end of, imagine a 4x4 quadrant, right? Do you modify content? Yes, no. Can you be sued? Yes, no, right? So there, if you don't touch content, you can't be sued. Other end is publishers.
Right.
You have editorial control.
You
can be
modify,
sued.
you can't be sued. Yep.
Right? It seems, correct me if I'm wrong, that Section 230 gives the social media networks, you could modify content and you can't be sued.
Right.
Which seems like the worst of.
Yeah, well, you
That's
should
for them.
you should have been here at Ryan's speech or Ryan's talk, exactly. Yeah, they've had a great deal for 20 years, and
Is that a correct?
that's absolutely correct.
Isn't that caveated by like the protected nature of some content, like copyright, trademark?
Well, right. I mean, so for instance, certain criminal speech, they're obligated, federal criminal speech. They're obligated for copyright under the DMCA. They're given privileges under Section 230 C2 to edit if they want to, but at their choice. They can't do, so there are a bunch of things, but in general, that is the exact problem.
What are the options or probabilities of these guys being ruled as publishers rather than being that special place in the quadrant?
Okay, so,
Being sued for, hey, you're clearly stopping speech from this group.
yeah. So this is actually, I mean, it's a sort of technical, weedy question, but you ask it, you get the answer. There may be a possibility that these laws are preempted by Section 230. So when a state says, no, you have to authenticate for age in order to get access to it, that might be preempted. The argument would be that Section 230 only protects the platforms for the content of the speech. For, if the content has some sort of libelous or unlawful content, the platform's not liable, as you described. This, we're not holding them liable for the speech. We're holding them liable for the access to it. So in other words, think of it as we're having requirements for entering the store. We're not holding the store liable for the content within it. So that will be our legalistic distinction. The Fifth Circuit bought it. We'll see how it plays on the road. So, but yeah, that would be the distinction, because Section 230 says you shall be treated as a publisher. Well, that's true, but letting someone into your store is not an act of publishing. So, yeah.
A couple of times you've brought up kind of the moral reasoning for your involvement and saying that, younger generation is, in your opinion, hurt by this. Has there been any kind of research done on that sort of thing? Like, how has pornography impacted the younger generations and the correlation between the relationship with satisfaction?
Actually, there's been much better research on social media. And I also do social media verification laws, so but I wasn't asked to talk about them. So, I think particularly the effect on young women is unquestionable. I mean, I'm always suspicious of social science, but the numbers that you're seeing are outrageous, and I see it in my classroom every day. So the porn is more ambivalent. There is a lot of bad data on. There is a lot of data on it, but it's hard. I don't think it's as clear. And as I said, there is a problem right now between the sexes. I think that is certainly obvious, and that something's wrong. As I said, I was ambivalent about going after porn because I think it's a very anti-male type of thing, and I think men in general, are getting a lot of crap in today's society. But on the other hand, if we restrict access, I just don't think it's going to be the end of the world. I mean, most men grew up in porn-restricted access, and they seem fine. Relatively okay. So, it's just not a hill that I'm willing to die on. So, if I could just change topic just quickly, and porn was interesting. This is boring, but it's related to Ryan's talk, and it has to do with another really important Supreme Court case, and it's Murphy v. Missouri, and I don't know if you're familiar with the Twitter files.
Oh, yeah.
Oh, yeah. So, in fact, I actually I wrote an amicus brief for the Twitter files journalists on this. So it's an issue that it's very important to me. So, as many of you know, during COVID, really eminent epidemiologists, people like Jay Bhattacharya of Stanford, were censored by the platforms for saying things that turned out not simply to be reasonable, but turned out to be true. It's like, oh, it's lab leak theory. Oh, vaccines don't stop transmission. Children, if you're over 60, get a vaccine. If you're 18, you probably shouldn't. This thing is also these issues are very emotional for me because I had a lot of trouble at my university, which had a mandate on students, these healthy kids, to get a vaccine that, from any normal perspective, they should not be, it's a risk to which they shouldn't be exposed. The reason why the platforms were in this censorship business, as the Twitter files journalists discovered, was that there really was an extensive cooperation between the platforms and government. To give just one example, and I'm running out of time, CISA, which the happily named Cybersecurity and Infrastructure Security Administration, for Orwellian, whatever that means. And if you look at the agency's organic statute, it said, "Oh, our job is to protect from foreign hacking." They got through Congress saying, "Oh, it's to protect us from Moldovan people who are going to come and do bad things to our computers." They expanded their purview to saying injurious to computers includes disinformation, both foreign and domestic. And it really is an example, and I'm not a paranoid. Trust me, really, honestly. Yeah, exactly. The fifth time I say this today. But it really is an example of this expanding administrative state whose job was to monitor, his eye of Sauron was supposed to be outside looking at the perimeter, has turned in on us. And what they did is they worked with literally Stanford University. People I knew in other lives, because I do a lot of internet law, and I would consider colleagues, people I go to conferences with, and they had them create databases and employed students to censor people. And they created these database systems that were then sent to CISA, so from Stanford to CISA, then CISA would present them to the platforms. And all of a sudden, people like Jay Bhattacharya, Martin Kulldorff, formerly of Harvard, anyone who signed the Great Barrington Declaration, which turned out to be, at least by my view and a lot of other people, the most reasonable response to the COVID threat, they were censored. Now, the question that the court is going to decide was whether or not that is First Amendment protected speech. Because if the platforms are private and they're doing that, the First Amendment has no effect. However, if they're simply, sort of puppets of the government marioneteers, then that is government action, that is state action, and the First Amendment protects it. So, oral argument is going to be this Monday. Look out for it. Yes.
Just a reflection as you bring up Jay Bhattacharya. So, when I was in high school, there was a few kids that did something stupid. Middle of the night, they removed a four-way stop sign out in the middle of the night, playing around. A few hours later, somebody ran that sign into, T-boned another car. Somebody died instantly. And then cops went, looked into it, found out who it was, found the kids. They were tried as adults. They ended up going to jail. Now, essentially, life-saving information was removed from a four-way stop sign, and people ended up dying. in that context, and this is part of how they were tried doing censorship, from my recollection. So now, move forward to a situation like this, where you have somebody who is accredited, putting out reasonable information, which is censored and removed. How is that, why are we not having a question even much higher than that, as far as like life-saving information being restricted and kept away from people, and actually, you discussed in the colleges being mandated
Yeah.
to expose these young people to now very questionable practice, which long-term implications.
Right.
Why are we not just, why is this a free speech conversation and not a potential manslaughter conversation?
Well, it's music to my ears. Back up the tape. Yeah, no. What can I say? I mean, I sympathize with you. I mean,
For me, I look at that and I say, either there has to be an apology to those kids who may or may not have gotten out of jail yet. I don't
Right.
know.
Right.
They were tried as adults for manslaughter.
Right.
Jump forward to something like this, which is much further reaching,
Right.
much larger implications, and many more people that would participate in it with not just a stupid action, but vested financial interests
Yeah.
in the outcome.
I mean, it's kind of an impersonal, emotional issue. I've had students who have, myocarditis, who were forced to take, and to me it was a personal decision. I mean, for some people it made sense, for other people it didn't. But it didn't make sense, and you can, roll the recording. For Michigan State University, a state institution, to demand that of young people.
Go back to tape.
And there is no apology. I mean, I think that's part of this. I mean, it's why I think FUTO is kind of important, because we live in a world of this unitary bureaucracy, and they're never wrong, and they can't ever admit to be wrong, and it's very discouraging. So yeah.
I think there's a bit more complexity that's happening. It's not merely life-saving information versus not. But I agree with you that they were right, and it would be nice for some what they were trying to do. They were trying to absolve themselves of liability. So in the future, I don't know, but there's nothing really that makes a good distinction that I know of that forces people to have a high-quality consensus versus a low-quality consensus. And I don't know if y'all can share.
Well, I mean, I'll give you a lawyer's response, which is, the First Amendment sort of answers that question, which is there is no consensus ever, unless there's clear and immediate danger. Okay. So taking down stop signs, there's a consensus there. There's a consensus for fighting words. There's a consensus to some degree, libel, making false statements. But beyond that, everything goes. And I think in society we've lost that. And part of the reason I think is technological. But I've talked too much, so I agree. Yes. Yeah.
Nikki Haley did that, mentioned that identity thing, and then she quickly got shut down. And it sounds like you're kind of a minor version of it with the age verification. What did you think about that mention, and then everyone kind of commentary around that?
Yeah, so it's like I didn't want to be on Haley on her side. Obviously I don't. I mean, I see real dangers in that. And on the other hand, as Alan was talking about, authentication is part of our lives. We can't really get around it. Whether we have to get on the internet and we have to authenticate as human beings eventually, so we're not, considered bots. Maybe we'll have to do that. But I want a world where we don't have to put our retinal scan in. And is it such possible? I think that's a technological problem. That's why I go to things like this. But the idea would be a decentralized approach, so that there's not one person with the key. Yeah.
I was just going to offer a simple solution or option to consider in the why is just not a manslaughter conversation. Tyranny has an inverse application of law. The poorer you are, basically. So kids need to be made an example of, but Twitter is going to be protected and praised for positive action. And I think it just goes that way.
Treason
So
never
the downstream.
prospers.
Say again?
Treason never prospers.
Right.
Right? If it prospered, none dare call it treason.
Okay, very good. Thank you.
All right. Thank you, Adam, and thank you, everybody, for coming to the first Lawn Society track at FUTO. I think it was, hope you guys learned something. As I understand, the